Jessica Blanche appearing on behalf of people.
We're ready in that matter, Your Honor.
This courtroom session wastes no time. Within seconds, we're thrown straight into a sequence of cases that, on the surface, look procedural, but underneath, each one carries serious legal weight and life-altering consequences. What you're about to witness isn't a dramatic jury trial with shouting attorneys. It's something far more subtle and, in many ways, more dangerous. Decisions being made quietly, efficiently, and sometimes in just a few sentences. Decisions that can define a person's future. Pay attention to how fast things move. Competency rulings, plea negotiations, bond arguments. These are the pressure points of the justice system. And here's the key. Most of these defendants won't get a second chance to argue these moments. When a judge decides competency or denies bond, that ruling sticks, and it shapes everything that follows. Now also notice the tone. Judge Simpson is calm, direct, and efficient. No theatrics. But that doesn't mean these decisions are minor. In fact, the quieter the courtroom, the more critical the outcome often is. Now ask yourself this as we begin. If your future depended on just a few minutes in front of a judge, would you be ready?
Juan Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Friday, who is appearing from the Washington County Jail.
That's Ms. Not going to ask her name, but that's her. All right. I have a competency report in front of me. Is that what we're doing today?
That is correct, Your Honor.
All right. Any other?
I'm sorry.
Go ahead.
We have no further evidence to present to the court.
Anything else from the people?
No, Your Honor, we stipulate to the report.
All right. Court in reviewing the report would find that the defendant is competent to stand trial. Specifically, the court would indicate that the defendant can understand the nature and objects of the proceeding against her and can rationally assist in her defense. Therefore, the defendant is deemed competent. Mr. Brown, we would need an order forwarded to the court at some point.
We will have that prepared for you, Your Honor.
All right. And what would you like me to set this for? A PCC?
Yes, please.
All right. PCC in this matter will be set. What date is that? The 20th.
2 weeks is the 13th.
All right, let's go 3. Just got to work on this one. Probable cause conference will be set for July 20th, 2023, 9 a.m. Bond in this matter will continue. Thank you.
Thank you, Your Honor. We'll have the report prepared right away.
Calls the case. People versus Peregrine Bork.
Good morning, Your Honor. Grace Bretton appearing on behalf of the people.
Good morning, Your Honor. First Assistant Public Defender Kalina Anderson with and on behalf of Mr. Bork. Mr. Bork, can you state your name?
You'll need to unmute or somebody unmute you, sir.
Mr. Burke?
Bork, not you.
Peregrine Bork.
Thank you. Okay, what are we doing?
Your Honor, in this matter, an offer's been extended. It would be a felony plea to an added count 4 of CSC 4th with the dismissal of counts 1 through 3 and an agreement to run a concurrent sentence with his St. Clair County.
Now this is where strategy comes into play. The prosecution is offering a deal. Plead guilty to one charge and the rest disappear. On paper, that sounds like a win, but it's never that simple. A felony plea for CSC 4th degree is serious. Even with dismissed charges, this kind of conviction can carry long-term consequences, registration requirements, social stigma, and limited future opportunities. But compare that to facing multiple counts at trial, where the risk could be significantly higher. This is the classic courtroom dilemma. Take the deal or gamble on trial. Notice how quickly this is moving. The defendant waives the preliminary exam without hesitation. That tells you something. Either the evidence is strong or the defense believes this deal is the safest path forward. Now think about this. If you were in his position, would you risk everything to fight or secure a guaranteed outcome, even if it costs you?
Sentence, which is holding him until November 30th. Mr. Bork wishes to waive his preliminary exam to avail himself of that offer.
That is all correct, Your Honor.
All right.
Yes, Your Honor. Thank you.
Is that all, Mr. Bork? Is that correct, sir?
That's correct.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right. People, for the record, also do waive their right.
We do, Your Honor. Thank you.
Preliminary examination having been waived, defendant is bound over to circuit court on all 3 counts. Ms. Anderson.
Thank you, Your Honor. We received a copy of the information, waive its formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as to all counts. Pretrial will be set for
August 2nd at 1:30 with Judge Conlon.
August 2nd, 2023. Is that right?
I know, that's why I hesitated.
That can't be.
That is the date I have for an MDOC.
Oh, for an MDOC.
Yeah,
Got it.
it is much later than
Well,
everything else's.
MDOC or anyone in custody?
I have a separate date for Washtenaw in custody. I have an MDOC writ date, which is August 2nd.
Wow.
Yeah. Which
Okay. Well, that's all right. I'll set it for August 2nd and you can get that moved up if you desire to. August 2nd, 2023, 1:30 before Judge Conlon.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you. Bye.
Thank you.
Continue. Calls the case, People versus Beverly Tuttle.
Nimish Ganatra, First Assistant Prosecuting Attorney for the people.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Ms. Tuttle. Ms. Tuttle, would you please state your name for the record?
Yes, ma'am. Beverly Tuttle.
Hey, what are we doing?
Good morning, sir.
Your Honor, we are asking for an adjournment. I did reach out to Mr. Ganatra regarding a potential resolution for this case. I would also like the opportunity to address bond.
Probable cause conference, July 13th, 2023, 9 a.m. as to bond.
Your Honor, it's my understanding from Ms. Tuttle that this is the only matter that is holding her in custody. I did have an opportunity. Let me start with, she did indicate that she has been awarded a Section 8 housing voucher. It is her belief that the voucher will be expiring in a few days, maybe as early as next week. She did have me reach out to her case manager at the Delanus Center, who's been working with her, who was able to confirm the housing voucher, as well as that it would be expiring soon. He did not know the exact date. He did also say he needed to speak to his supervisor before he could write a letter. I have not heard back from him. I plan on following up, but this housing would be a game changer for Ms. Tuttle.
This is one of those moments where the human side of the legal system comes into focus. The defense isn't just arguing law, they're telling a story. Housing stability, medical care, mental health support. These are all being positioned as reasons to release her. And strategically, it's smart. Courts often consider stability as a factor in bond decisions. If someone has a place to live and access to treatment, they're less likely to reoffend or flee. But here's the tension. The prosecution is about to counter with her past. This is where courtroom narratives clash. Rehabilitation versus risk. Ask yourself, should someone's future opportunity outweigh their past mistakes?
It's also my understanding from Ms. Tuttle that she has been working with her primary care physician out of Packard Health, who has referred her to behavioral services to get her back involved with mental health services. So she anticipates starting that upon her release as well, which would be for medication management and potentially also therapy.
Anything from the people?
Your Honor, she failed to appear to community corrections back in May. There was a report dated May 19th. And I think that coincided with a bench warrant for failure to appear at a PCC in May of this year. I score her guidelines at 5 to 23. She has prior felony convictions for custodial interference, kidnapping, larceny in a building, uttering and publishing, forgery, misdemeanor conviction for operating while high BAC. This incident involves her being in possession of a loaded firearm, also having cocaine in her possession when she came into contact with the Ann Arbor Police Department. If the court's inclined to release her, the people's concern would be that she have some type of testing in place to ensure sobriety.
And just like that, the tone shifts. The prosecution lays out a pattern: prior felonies, substance issues, and now a firearm and drugs in the same incident. That combination is a red flag in any courtroom. From a legal standpoint, this is about risk assessment. The judge isn't deciding guilt here. He's deciding whether she can be trusted outside custody. Notice how the prosecutor emphasizes failure to appear and prior attempts at supervision that didn't work. That's not accidental. It's designed to show the court, we've tried leniency before. It failed. This is where past behavior becomes powerful evidence, not of guilt, but of reliability. So now the balance shifts again. Second chances versus public safety. What matters more?
And we've already tried that and it didn't work.
Yeah.
May I address just a couple things? Mr. Ganatra did go through Ms. Tuttle's criminal history, which we'll acknowledge. But I do also want to say that up until fairly recently, she had 13 years of sobriety underneath her belt. This is a recent relapse. If you look at the dates of the convictions, they are much.
How did she come back into custody?
May I speak to you, Your Honor?
How did you come back into custody, Ms. Tuttle?
I had returned to Ann Arbor on the night I was arrested. I had been assaulted, and had.
So she didn't turn herself in. What else do you want to say to me,
Excuse
ma'am?
me, are you talking about original arrest or now that I'm in custody here?
I'm talking about on the bench warrant where you failed to appear for court and you failed to go to testing at community corrections.
First of all, sir, upon my original arraignment, when I was given the PR bond, I did show up at community corrections. When I went to community corrections upon my release, the form that they gave me to take to community corrections was empty. There was no indications of how I was supposed to be tested, what I was supposed to be tested for, or anything of that nature. The woman, I signed the sheet at community corrections. You can verify with them. I was there. I did show my ID. I did sign in. The woman that was at the desk sent me to 14-1. I went across the street. I went into 14-1. I talked to the two black ladies that were behind the window. I gave the one my paperwork. I was on borrowed time because I had a ride from someone else. She disappeared with my paperwork for like a half hour. And I kept asking if I could get my case number, if I could get my public defender's name. And there was no information that they could give to me. And I had to leave. All of my court paperwork was left there at 14-1. I didn't have my case number, a public defender's name, nothing. And I did make multiple attempts to try to make contact to get this information. But I did show up to community corrections as ordered with a blank piece of paper, and they said there was nothing they could do for me. Also, at my original arraignment for this case, the magistrate told me, because I explained to her, my disability is in final pending stages. And I told her I did not have the money to pay for the testing. And she told me that they should be able to work out something with me. When I went to community corrections, they told me that unless I could pay for it at the time of testing, there was nothing they could do for me.
Motion for bond reduction denied. Bond will continue. Thank you.
Can I just?
That's decisive. No hesitation, no negotiation. The bond stays. What just happened here is a complete rejection of the defense's narrative. Housing, treatment, explanations. It all gets overridden by one thing: lack of trust. From the judge's perspective, the inconsistencies and prior failures were enough to justify keeping her in custody. And once that decision is made, it's hard to reverse without new evidence. Notice the final tone: firm, almost final. I ruled. I'm done. That's authority being asserted. This is a reminder of how much power a judge holds in these moments. One decision, delivered in seconds, can keep someone behind bars for months. Do you think the system gave her a fair chance? Or was the outcome already decided?
Can I just clarify one thing, Your Honor?
Oh,
Yes.
There was a representation made about 13 years sobriety for her. Is that what I heard?
That is what Ms. Tuttle relayed.
Your Honor, there's a conviction from
Yeah.
February 2015 for operating with high BAC. The date of offense was November of 2014. That was in 14B District Court.
Yeah, I will say that
Oh, my apologies.
Ms. Gaines can only represent to the court what her client represents, and that is just one of many misrepresentations that have been made. So
My
I
apology.
will
My
take that
apology.
into,
I have
Ms. Tuttle,
multiple
Ms. Tuttle,
CIs.
I ruled, I'm done. Thank you.
I'm sorry, sir.
Court calls the case. People versus Gregory Lewis Taylor.
Jessica Blanche, appearing on behalf of people.
Good morning, Judge Simpson. Attorney Carl Jordan, P number 57226, appearing by Zoom on behalf of Mr. Gregory Lewis Taylor. Mr. Gregory Taylor is appearing by Zoom, and this is with our consent, Your Honor.
All right, thank you. All right, what are we doing in Mr. Taylor? Can you state your name, please, sir?
Gregory Taylor.
Thank you. All right, what are we doing on this case?
Your Honor, I had an opportunity to speak to Madam Prosecutor yesterday. I need to get her some information that I think might help to resolve this case in the long run. May we have another PCC, please?
This is a quieter moment, but it reveals something important. Negotiation is happening behind the scenes. The defense isn't ready to proceed. They're working toward a potential resolution. When a defendant asks for time, it usually means one of two things. Either they're building a defense or they're negotiating a deal. The judge grants a new date without objection, which tells you the prosecution isn't pushing back. That often signals cooperation. Both sides may be moving toward an agreement, but time cuts both ways. Every delay can help preparation or increase pressure. Here's the engagement question. Do delays in court help justice or just prolong uncertainty for everyone involved?
Yes, would you like 13th or the 20th, sir?
Could we have the 20th, Your Honor?
20th.
Yes.
Probable cause conference will be adjourned without objection. July 20th, 2023, 9 a.m. as your Zoom vote indicates. Bond
I'll come to
continues.
see you, Mr. Taylor. We're working on some things for you. Thank you, Your Honor.
Thank you.
Thank you, Ms. Blanche.
What calls the case of the people versus Ashraf? Is it Ragheb?
Yes, Your Honor.
Good morning, Your Honor. Ali Zenda on behalf of the people seeking permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Caitlin Kirby.
Good morning, Your Honor. Alexander
Permission to
Hermanowski
practice is
on
granted.
behalf of Ashraf Ragheb.
Permission to practice is granted. Now you may go ahead, Mr. Hermanowski.
Sorry, Your Honor. Alexander Hermanowski with and on behalf of Ashraf Ragheb. Your Honor, we are here for this is a time and date set for a probable cause conference. I've spoken with Ms. Kirby. We have come to an agreement, and we have submitted the plea to the court last night.
Mr. Ragheb, can you state your name, please, sir?
Ashraf Ragheb.
All right. The court has before it a plea form that indicates the defendant would be pleading no contest, and I don't know how that's going to happen because I don't have a police report.
This is a procedural red flag, and a serious one. The court is being asked to move forward with a plea, but the judge is missing a critical piece of the puzzle, the police report. That document outlines the factual basis of the case, what happened, how it happened, and why the charges exist. Without it, the judge is essentially being asked to approve a legal outcome without verifying the underlying facts. That's not just unusual, it's risky. Courts rely on documentation to ensure that any plea is supported by evidence and that the defendant fully understands what they're agreeing to. Notice how quickly the issue is identified. Judge Simpson immediately pauses the process. This shows a key principle. Efficiency matters, but not at the cost of due process. This moment highlights something deeper. Courtrooms are not just about decisions. They're about verification. Every step must be grounded in record. If you were the judge, would you proceed based on trust or stop everything until you see the proof?
Hello?
Your Honor, I can mail you a police report quickly.
Pass the matter. Court calls the case, people versus Michael Adante.
Ali Zenda on behalf of the people.
Morning, Your Honor. Lawrence H. Margolis on behalf of Mr. Adanti. I'm sitting in for Janan Hamoud. Today is the date and time set for, well, let me just say this. He is still in treatment, Your Honor, and we are seeking a 30-day adjournment. Ms. Hamoud is in the process of getting documentation, waiting for his release of information to hit her file. He does have an out date of July 25th. We are advised this morning. And so that is why we are requesting a 30-day adjournment. We are trying to screen, we've been screened for sobriety court. And Mr. Reyes thinks that he is a good candidate, but apparently they have to clear up some issues with Judge Washington.
Mr. Dante, can you state your name, please?
Michael Daniel Dante.
Thank you. Any objection to the adjournment by the people?
No, Your Honor.
Probable cause conference in this matter will be adjourned July 27th, 2023, 9 a.m. or Zoom invite indicates bond continued. Thank you.
Thank you, Your Honor.
Thank you.
Yeah. Court calls the case, People versus Chauncey Hyman.
Jessica Blanche, appearing on behalf of People.
Ready, Judge. Torshell Feaster, Assistant Public Defender on behalf of Mr. Chauncey Hyman. Mr. Hyman, please state your name for the record.
Chauncey Maurice Hyman.
Thank you, Judge.
Hey, what are we doing?
I've actually had to speak to Ms. Blanche on this matter and to Mr. Hyman. My understanding is that this matter had previously been set for exam. This is a recharge. Mr. Hyman,
Yes.
you to set this matter for exam again, please, at the court's earliest convenience.
Preliminary examination will be set for July 11th,
Thank you, Judge.
2023, 9 a.m. That is before Judge Burke.
Judge,
Well, who was it before?
Valvo, Judge.
It was before Judge Valvo?
Yes, Judge.
All right, it stays with Judge Valvo, so that makes the preliminary examination the 18th
Thank you,
before
Judge.
Judge Valvo.
And I believe Mr. Hyman wanted me to address bond if you would entertain that.
Go ahead.
Thank you, Judge. As the court is aware, this matter was dismissed at exam. My understanding when talking to Mr. Hyman is that he is at risk of losing his apartment, a substantial financial loss, and he has no objection to being on tether or following any other of the court's rules. Should the court put him on tether, he was hoping Your Honor would consider a tether and under personal bond in this matter, Your Honor.
Response.
Judge, bond was addressed the first time it was written. Obviously, at the second arraignment, the judge at the arraignment knew this was a rewrite. Our victim was there. She's terrified of the defendant. She could not appear in person. She tried to appear on Zoom. She was not allowed to. We're going to proceed on the case regardless if she's there or not. There is a possession by felon and a felony firearm attached. He pointed a semi-automatic pistol at her. It was loaded. He said, "You check these rounds." He had one round in the chamber. The hammer was back.
This is where the stakes escalate sharply. The prosecution isn't just describing a crime. They're painting a picture of immediate danger, a loaded firearm, a direct threat, and a victim who is reportedly terrified. In bond hearings, this kind of detail carries enormous weight. It's not about proving guilt yet. It's about assessing risk. And when weapons are involved, especially with allegations of pointing and readiness to fire, courts tend to lean toward caution. Notice the language. Lethality. Concerning. That's deliberate. It signals to the judge that this isn't just another case, it's one with potential for severe harm. The defense tries to argue stability and compliance, but in moments like this, safety often overrides everything else. Ask yourself, when a case involves this level of alleged threat, should release even be on the table?
The lethality on this case is concerning, so we ask that you don't change bond.
Anything else, Mr. Feaster?
No, Judge.
Motion for bond reduction is denied. Bond will continue as set.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
In custody, Court does call the cases of the People versus Nathaniel Davis.
Good morning, Your Honor. Alex Chabalowski for the People.
Good morning, Your Honor. Lawrence Margolis on behalf of Janan Hamoud. On behalf of Mr. Davis, please state your name, sir. Mr. Davis. Mr. Davis, please state your name to the court.
Defendant Lamont Davis. And Your Honor, Zachary Ward on behalf of Mr. Davis in 23 F5 5115.
Judge, today's
Okay,
a
what do we do?
it's a date and
What
time.
are we doing on these?
It's a competency hearing today. Ms. Hamoud advises that on June 27th, she spoke with Dr. Suresny at the Forensic Center. He has interviewed Mr. Davis last week, I believe, but the doctor advises he needs additional time to prepare his report. He's also requested additional medical records that he would like to review before compiling his report. And he believes he says he needs about 4 weeks from the date of his interview. So Ms. Hamoud is asking me to request a month adjournment, 30-day adjournment.
Now we return to competency, but this time it's incomplete. The doctor needs more time, more records, more evaluation. That tells you this case isn't straightforward. Competency evaluations can be complex, especially when mental health history is involved. The court can't move forward until it's certain the defendant understands the proceedings and can participate in their defense, so everything pauses. Not because of legal strategy, but because of uncertainty. This is one of the few moments where the system deliberately slows down. And for good reason. A wrong competency ruling can undermine the entire case, but delays also create tension, especially for defendants sitting in custody. Here's the engagement question. Is it better to delay justice to ensure fairness, or move forward and risk getting it wrong?
Competency hearing, that being on the case ending in 5524, since we do not have a report at this point, will be adjourned to July 27th, 2023, 9 a.m. And on that matter, bond will continue. What are we doing on the other case?
Your Honor, we also would like to see the results of the report. So if my case could just tag along.
Probably. Good. We'll adjourn the probable cause, July 27th, 2023, 9 a.m. Bond continued. Thank you.
Thank you, Judge.
Thank you.
Yeah. Court calls the case, People versus Nicholas Mercer.
Nimish Ganatra for the people.
Ready, Your Honor. Robert J. Kill on behalf of Nick Mercer. Nick, would you state your name for the record, please?
Nicholas Edward Mercer.
Judge, in this matter, I had a chance to speak with Nick. We believe that if an exam were held, you would bind this matter over. That being said, and Nicholas agrees that we'd like to waive up to circuit court.
Is that correct, sir?
That's I mean, there's actually like more to it. I mean, that's not necessarily the whole thing is I've been here for 6 months.
Nicholas, hold on a second.
This hesitation right here is telling. You can hear it in his voice. He starts to explain, to push back, to add context, but then he's quickly redirected back into the legal process. Waiving a preliminary exam is a big decision. It means giving up the chance to challenge probable cause early. And while his attorney frames it as strategic, moving toward a global resolution, it's clear the defendant himself has more to say. But here's the reality of courtrooms. Timing and structure matter more than emotion. If there are multiple cases pending, like here, the system often pushes toward consolidation rather than individual arguments. So the waiver goes through. This moment raises an important question. How often do defendants fully understand the implications of these decisions? Or are they just following legal guidance under pressure?
You've got 3 matters up in court already represented by Stewart.
No, I got 4 matters.
We're going to get this matter up there for a global resolution.
Yeah, correct.
All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that this offense alleged was committed and that you committed it.
Right, yes, sir.
All right, you understand you'll not have that hearing and you'll proceed it to circuit court and join your other cases.
Right, yep.
Okay. People also waive their right?
We do.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Killowall.
Your Honor, acknowledge you received the information, waive its reading. My client will stand mute. My client believes he has a pretrial on July 5th. Is that true, Nicholas?
Yes.
Is it possible?
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. What pretrial date do you have on this?
12, I don't have it.
We have the 12th. We do not have the 5th.
Judge,
What?
Yeah, it's the 5th.
I'm sorry.
I can do it one of two ways. I don't think Judge Conlon will have a problem if I set this for the 5th. I don't know if the file will get down there. It usually is, it should, but it's usually what I do is I set it for the 12th and then you contact their office and they make sure that it gets on for that day.
Judge, let's do that, Judge. I'm going by what my client's saying. Let's set it for the 12th and I will call the Judge Conlon's office.
All right. Pretrial July 12th, 2023, 9 a.m. Bond continued.
All right,
Thank you. Court calls the case, People versus Michael Roberts.
Jessica Blanche, appearing on behalf of the people.
Ready, Judge. Torshell Feaster, Assistant Public Defender on behalf of Mr. Michael Roberts. Mr. Roberts, please state your name for the record.
Michael Roberts.
Thank you, Judge. Mr. Roberts also has a couple cases up at Circuit Court. We adjourned those yesterday out to July the 12th. I am requesting that this matter go 2 weeks as well, potentially to the 13th if that fits the court schedule, so that we can see about trying to get this matter resolved. I did receive an offer from the people, and I do know Mr. Roberts is hoping for a bond. We're working on that in Circuit Court. If we're able to reach a resolution there on a bond, I'll reach out to Ms. Blanche to see if she'll consent to a stip. But at this time, I don't have an argument.
All right. You know, Mr. Feaster went about trying to pick his date. He didn't learn.
I thought I did it in a very nice way.
I think he realized after he said it, he did it. But if there's no objection, I'll adjourn it out to the July 13, 2023, 9 a.m.
Yeah.
Defendant's bond. Oh, I'm sorry, Ms. Bond.
No, I'm fine with the adjournment, but I did want to address bond.
Okay.
I can,
Go ahead.
Judge,
Go ahead.
He's been contacting the victim in the case, so I'm asking for you to revoke his jail phone call privileges. In fact, on phone conversations, he's told her not to show up to exam, that the case will get dismissed and dropped. So he's not supposed to be contacting her. I'm asking you to revoke his phone privileges.
I was there. Ms. Blanche did notify me that notified me about that this morning, Your Honor. I have not had a chance to speak to Mr. Roberts about that. If the court is inclined to restrict his phone privileges, I'd ask that the court restrict him and admonish him not to speak to the alleged victim in this matter, but not to restrict his total ability to make phone calls from the jail. And I will have a thorough and direct conversation with Mr. Roberts about contacting the complaining witness in this matter now that I'm aware of the allegation and what's happening, Your Honor.
Well, certainly I would review that on the 13th, but what it sounds to me like is that these are phone conversations that are, if true, would amount to some type of an obstruction of justice or witness intimidation or and the like, which is probably more problematic than the phone calls themselves. So I will adjourn this out to the 13th. Regarding his bond, his current bond is set at how much? I got 5,000 personal.
He's probably being held on the circuit court matter, Judge.
Yeah, I see a person.
Well, I'm going to do two things, at least pending the hearing, and I'll look at it again. The defendant's bond is going to increase based upon the representations to the court to amount of $10,000 cash surety bond. Defendant's phone privileges are hereby ordered revoked pending that hearing on the 13th and additional information provided to the court. Thank you.
Thank you, Judge.
This is one of the most serious reactions we've seen so far. The judge isn't just denying a request, he's escalating consequences. Why? Because of alleged witness intimidation. If a defendant is contacting a victim and attempting to influence their testimony, that crosses into obstruction of justice territory. And courts treat that very seriously. The bond is doubled. Phone access is cut off. These are immediate, tangible penalties. And listen to the warning that follows. If he tries to bypass the restrictions, he's not getting out. That's a direct line being drawn. This moment shows how quickly things can turn. One allegation, if credible, can completely change how the court views a defendant. So consider this. Should allegations like this trigger instant punishment or require more proof first?
So that means no calls at all? I can't call
No calls at all except to your attorney. That's it.
Okay.
I'll look at it again. And I'm going to warn you, sir, if I find that you may be trying to make calls through other devices or other people's accounts, I don't care what happens in circuit court while it's here, you certainly will not be getting out of that jail.
Okay,
Am I clear?
You're clear.
Thank you.
Yep.
Thank you, Judge.
Calls case of the People versus Christopher Haar.
We're ready in that matter, Your Honor.
Jessica Blanche, appearing on behalf of people.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Haar. Mr. Haar, please state your name for the record.
Christopher Charles Haar.
Your Honor, today is the date and time set for the probable cause conference. At this time, Mr. Haar is respectfully requesting that the earliest preliminary examination in-person date be set.
This is the only thing holding him?
Yes, Your Honor.
Okay. Would the people be ready to go? Sorry, would the people be ready to go on July 6th?
Judge, I would prefer the next date just because of the holidays. I haven't spoken to the victim about her availability on the 6th.
Preliminary examination will be set July 11th, 2023.
May we address the issue?
9/8 or, pardon?
Maybe address the issue of bond at the first.
Yes, before Judge Freshour. As to bond.
Your Honor, the bond is currently set at $1 million. My client has no prior assaultive history, has no prior convictions. He's lived in Michigan all his life. He's asking that he be allowed to be placed on a GPS tether with a personal recognizance bond and even a sober link if the court feels that is appropriate. He strongly believes in his innocence. He believes that he will be vindicated once all the facts are in this case. If he remains in custody, he stands to lose his job and his house and his car. He's been working steadily at Baker Construction for the past 17 years. He is a stable individual, no prior criminal history. He believes that these charges will not be supported by any evidence, and he's asking to be allowed to be free so that he does not lose his situation based on these charges.
Response.
Judge, my concern is the facts in this case. The victim was found in a ditch. She had blood all over her. She went to the hospital. In the hospital, she had multiple fractures to her nose. Her orbital bone was fractured. She had contusions all over her head area. She had a brain bleed and a TBI. So the significant amount of injuries in this case are highly concerning. I understand he has no assaultive history. However, this is a very serious case regarding the injuries, Judge.
Your Honor, we understand that the injuries are serious. My client denies responsibility for those injuries, and that's what's important and key here. He can certainly have no contact with the complaining witness, but it's important that he does not lose his life and livelihood based on these allegations, which he strongly denies.
I mean, I understand also the alleged victim being found by the side of the road. My notes also indicate that her body was wrapped in a carpet on the side of the road.
I think it was a blanket. That's what the 911 call had.
Okay. Not a carpet, but a blanket.
Well,
Okay.
I mean, that was what was a presented arraignment, but we have spoken to the victim since then. I think her legs were inside her sweatshirt. So I don't believe she was actually wrapped in a blanket, Judge, after speaking to her, but that's what the 911 call had said when it came out. But to be candid, I mean, we have spoken to her since and
Got it.
the information I was relaying.
Okay. Considering all that, I don't find, given the circumstances, the magistrate abused their discretion in setting that bond. So in this matter, the motion for bond reduction at this point will be denied. Certainly Judge Freshour can take that up after exam. So his bond in this matter will be continued. July 11, 2023, 9 a.m.
Thank you.
Thank you.
This final decision brings everything into focus. The defense presented a strong argument. No prior history, stable job, long-term employment, community ties. On paper, this is exactly the kind of profile that often qualifies for bond reduction. But the prosecution countered with something far more powerful: the severity of the alleged crime. A victim found severely injured, multiple fractures, a brain bleed. These are not minor details. They reshape the entire case. And that's what the judge ultimately relies on. Not just who the defendant is, but what the allegations represent. This is the core tension of the justice system: presumption of innocence versus protection of the public. Across all these cases, you've seen patterns: competency decisions, plea deals, bond denials, adjournments. Each one is a piece of a much larger system where every decision carries weight. Some defendants move forward, others are held back, but every ruling shapes what comes next. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.